and within 72 hours, you have to provide updated details. You also have to provide details of the remedial measures that you are going to take as a data fiduciary, then what has been your finding of the breach, and also notify the data principals whose data has been breached. Then regarding cross-border flow, so we saw in the act which was notified in 2023 that you are allowed, as data fiduciaries, were allowed to transfer data only to the, but there are certain countries which are blacklisted where you won't be able to transfer the data. But there has been a certain change here. Now we see that we are allowed, or like the data fiduciaries, they are allowed to transfer data only if you oblige or you are meeting the requirements laid down by the central government or requirements that have been notified by the central government. Only then you are able to transfer it to a foreign state or to abroad. Then some of the key concerns that has been raised, I think this is something that we will be discussing in depth in our discussion today, but I'll just go briefly on the key concerns that has been raised in the ecosystem. So first is the cross-border data flow restriction that I already mentioned, that there are certain requirements that you need to meet in order to transfer data, which is not there in the act before. Then also you have different rules for significant data fiduciaries and for smaller entities. So if I am a SDF, I am restricted from transferring certain data abroad, but a smaller entity will be able to transfer the same data. But since we are talking about data protection here, there should not be difference in terms of entities transferring data, because why should we have different obligations for SDFs and for smaller entities regarding the same data? Then we also have the age verification mechanism for children. So this might lead to falsification of age, and also there is a restriction on behavioral monitoring. So if you look at the restrictions on behavioral monitoring, we are not allowed to track children's data or what are the activity that children are taking up online. So there is a restriction of behavioral monitoring, which might also prevent us, or which might also expose children to content that they should not be looking at, because there is a restriction on behavioral monitoring. Then you also have consent requirements for people with disabilities, but it doesn't say to what extent or what are the different disabilities that have been covered, the extent to which, whether a person is able enough to give consent. That is not something that has been touched upon. And the another concern that has been raised is the mandatory data deletion. So there is a data. So after 3 years, if we look at the schedule, after 3 years, e-commerce companies, gaming companies, and social media companies who are supposed to remove the data. And I think with this, I'll stop here and I'll pass it on to Amrita to take it over from.
Thank you.
Thanks a lot for this, Shraddhanjali. And I think what we would be doing is we will go on to our panelists, and we would actually ask them the first question. And the question would be, as you look at the draft regulations, what works and what doesn't work for you, or what would be the key concerns? And I could possibly start with Vishal. Vishal, you come from the startup ecosystem, etc., as well as looking at from the health sector. So how do you look at it? What are the concerns you see here?
Sure. So I think this is a topic very, very close to my heart. And we think that startups, there's so much happening on digital side, and the whole economy, the new age economy, is built on technology and digital. And if the new data protection does not take care of the 360-degree perspective of all the stakeholders involved, I think it may not be a sustainable growth, opportunity. And I feel that it's very good that you guys are timely organizing this consultation process. Now, coming to the health part of it, coming to the healthcare part of it, how digital health is a sector, and we've also invested in many companies in digital health. And we think that certain aspects of the, business models which require a robust data protection has not been covered yet. I think Punya, you wanted to say something?
No,
Okay.
I think we'll get it muted. Let's have the
All right.
speakers speak first. And Swati, if you could look into it, please.
Sure. So I was looking at healthcare perspective, which is basically looking at AI in healthcare. Now, the fundamental of any digital healthcare business is actually looking at AI, and AI is enabling the remote, I would say, remote patient monitoring, remote patient diagnostics, all that. Now, how do we ensure that the data is protected and there's no monetization? Because we see sometimes, people do talk about monetization of data. Now, there is a kind of a gray area, right? How much to monetize, what shape and form is right to monetize. I think it's important for investors like us to see the monetization, but then what it is to be allowed in terms of sharing the data and what is not so allowed to share. I think there is probably not much clarity on that. So, you deal with patient data, right? And if you're dealing with patient data, there are sometimes even children data is very, very crucial, and those data are very easily available, especially with doctors, a vaccination record, or it could be about assistive technology, it could be about orphan disorders, it could be about diagnostics, it could be about disease, it could be about pharmacogenomics. So there are a lot of moral and ethical issues which one has to deal with, and I hope that this particular Digital Protection Act does throw some light and create some kind of a mechanism to take care of the interest of all the stakeholders, to make digital healthcare more accountable, accessible, and affordable as a sort of a technology to enable access to 1.4 billion people in India from a healthcare perspective. Because today you cannot think about healthcare just sitting physically. It has to be thought through from phygital meaning, which essentially incorporating digital strategy in the physical setup. I think this is what I wanted to share. There are moral, ethical issues which needs to be sort of debated, discussed, to make at least digital strategy robust for all the organizations in the startup world, especially so that they can scale, and they scale ethically, they scale morally, and they're able to really provide a deeper access to healthcare, to patients where otherwise it wouldn't have been possible. So these are my opening comments, Amrita. And if you want something specific from me, I'll be happy to address. Otherwise,
Yeah.
I'm still learning about this aspect, but I'm glad that you invited me to be able to participate in that, and so I'm looking forward to learning from each one of you. Thank you.
Thanks so much, Vishal. We are trying to actually encourage all stakeholders to come in, especially those who have not been involved, those who have been looking at innovation only. And that's why we have a very diverse set of panelists. I would perhaps go to Uthara next. Uthara, you all deal a lot with children's data, as in, how are you looking at the rules and what do you see as concerns?
Amrita, thanks so much for having me. First of all, super nice to be here. So just for context, Snapchat, as many of you know, primarily has a young audience, right? So about 80% of our user base is between the ages of 13 and 24. So unsurprisingly, the main issue that I want to focus on today is verifiable parental consent and the overall treatment of children's data under Section 9 of the law and Rule 10 of the rules. But before I comment on the brass tacks, right? I did want to take a step back and situate the overall public policy objective of this section. Now, ostensibly, the public policy objective of Section 9 and Rule 10 is, broadly speaking, to create a safer internet for those under the age of 18, right? And more granularly speaking, I guess this could mean that there are fewer privacy harms and other types of harms that under 18 folks are subject to. Now, I want to be unequivocal that Snap is completely supportive of this overall public policy objective, right? But I do think, Amrita, others, that we need to double click on whether or not this verifiable parental consent approach in and of itself gets us to where we want to go, right? I also want to comment on the rules specifically at two levels, right? One is a more pragmatic, how can we work with what we have perspective, and the one is a more fundamental perspective of what's the right thing to do by children and in terms of ensuring their safety, right? Now, in terms of the more pragmatic perspective, I think it's important for us to acknowledge that the original sin really is contained in the parent law, right? Which sort of is explicit in that what we need from fiduciaries is verifiable parental consent. Now, I could get into this in more detail, but essentially over the last 2.5 years, a number of us have talked about why this idea of verifiable parental consent is basically an impossible problem to solve, right? You have to verify the age of the child. You have to verify the age and ID of the parent. And then you also have to verify that relationship between the parent and the child. And I think what we've learned in the last 2 years is that there's no easy way to do this anywhere in the world accurately and without a significant type of privacy or cost or product friction trade-off, right? And I think what's happened in the rules is that we've seen that MeitY is kind of reconciled with the fact that, hey, this is a difficult thing to do, right? And I think what they've sought to do, which I think, by the way, is quite welcome, is to make the rules as workable and implementable as possible. Of course, the lawyers will look at this and be like, hey, this completely undermines the Parent Act. But from a more practical compliance perspective, I think what they're trying to do is make this somehow work for fiduciaries, right? So they've not been explicit, for instance, in demanding hard verification of the child. They're also not asking for a hard verification of the parent-child relationship. But there is still a need to collect verifiable parental consent. Okay. Now, from Snap's perspective, the remnant problem with this is that the mechanism to collect verifiable parental consent is slightly harder if you don't already have reliable existing details of the identity of the parent, right? What we have to do is Snap, and I think a lot of other non-ubiquitous, medium-sized, awkward-sized platforms will need to basically build a parental consent flow from scratch, right? And either hard verify using ID or somehow integrate with DigiLocker or some sort of certified third party to make this happen, right? And to my mind, right, there's a bit of a problem there. One, because we're continuing to have this data maximization problem that is inherent with the proposition of ID verification. But I think the other thing that's happening over here is that we are also creating unwittingly a bit of a data moat, right? To my mind, I think the current framing of Rule 10 is a classic example of a provision that was really intended to create more accountability for big tech and large companies, etc. But what's ended up happening is that because it's so difficult compliance-wise, we're actually going to end up entrenching the very, very large platforms, right? So from a solutions perspective, what can we do to address this? In my opinion, we'll have to propose some language for amendments to 10.1, which basically clarifies that parents who are also not existing users of a platform can apply for accounts to provide this verifiable parental consent, right? So that's my more pragmatic take on how do we make this work. But more importantly, and I think this is a slightly more serious, if not connected to DPDP point, I think zooming out, we need to examine if we can, as the tech policy community, have a slightly more earnest discussion about whether or not this parental consent led approach to children's safety is adequate, right? My feeling is that, especially as we're watching the social media and young people's mental health and safety debate blow up everywhere in the world, is that parental consent is no silver bullet to children's online safety. We need to do more, right? We need to potentially have a separate considered discussion on the need for a thoughtful, risk proportionate framework that basically nudges platforms to do more and be more responsible for the kinds of designs that they have on their product, right? So I know that's not necessarily connected to the DPDP per se, but I do think we'd be remiss by saying, stopping short by saying, hey, make VPC work, but then not really address the bigger problem here of how do we keep children on the internet safe. So TLDR, we have a parental consent requirement. We need to somehow make that work. So without having too many unintended consequences. So we have some solutions there. But number two, we need to have a separate, earnest discussion about children's safety on the internet outside of the DPDP. I'll stop there.
Thank you so much, Uthara. Yes, having a discussion about children's safety overall is also important, not only the privacy consent issue, but for the other aspects. With that, possibly we'll move to Jhalak. Jhalak, you come from an academic background and you look at it from a civil society perspective also. How are you, looking at the bill? What are your concerns?
I think, my overarching concern with the rules is really the fact that they don't get into the level of detail and operationalizing clarity that you would typically expect from delegated legislation. In many of the provisions, it seems almost like there's been a bit of a tweaking of the language that we saw in the Act around certain provisions. And, very similar language is sort of articulated in the rules. The whole point of rules is to give clarity on operationalizing, and in various places throughout the rules, it seems to be left to industry platforms to figure out how to operationalize. Now, accounting for the fact that, of course, there are many different kinds of internet platforms or sort of companies that will have to comply with the rules. The fact is that I think the rules could have, and you cannot have a homogeneous approach to application and operationalizing, but the rules could have definitely done a lot more in the level of specificity and direction it articulated in the course of what the government has put out. I also feel that one of the other sort of big challenges I'm seeing is that there are elements in these rules that are really going beyond what has been envisaged under the Act. So, for instance, the data localization provisions that seem to have come in through the rules, the Act doesn't really deal with the idea of data localization, and has taken, previous versions of the law, proposed law did have some provisions, but this is now coming through the rules. It seems like something that should actually be articulated in the Act and then operationalized through the rules, rather than something that is being brought in through the rules at the first instance. Agreeing that there may be some geopolitical considerations and realities, we are seeing even that play out between the EU and US around data localization. And perhaps there are certain sensitive sectors, like we've seen in India, around financial services, health, where it may be desirable, but these discussions should not happen through a committee that is being set up through delegated legislation. Rather, these discussions should happen in Parliament and be operationalized through an Act. And if there has to be any such committee or decision-making body, it has to be set up by Parliament. So, and other instances, the Data Protection Board that has been set up, and that the Act, it was primarily sort of thought of as a dispute resolution mechanism. But we're seeing through the rules that various elements of regulatory powers are being put within the ambit of what is being envisaged as the Data Protection Board. And, while many of us would have been very happy to have a regulator, and instead of, just a grievance redressal mechanism, plus the ministry taking on a lot of regulatory powers, to have a specialized regulator with members who have a tremendous amount of experience on these issues would have been great. But, given that the Act does think of this as a grievance redressal mechanism, we should stay within the confines of that rather than extend the powers that are envisaged for the Data Protection Board. But, there's a lot more to say, but I'll stop here as my initial round of comments.
Thanks so much, Jhalak. Perhaps at this point, I would bring in Meghna, and Meghna comes from the gaming industry, and there is a specific section also on for the industry, etc. So, Meghna, many of the rules impact you in many ways. So, if you could share your views on it.
Thanks, Amrita. So, firstly, thank you for the opportunity to present my views on this panel. Deep diving into the DPDPA and the rules that have been introduced, a few initial thoughts before we really dive into the sort of issues that we do see from the draft that has come across. From a perspective of a tech company, I mean, what we are very aware of is the fact that not a lot of users, or even as a user of many services, right? We're not really in the practice of going ahead and reading privacy notices and actually seeing what we are consenting to, what we are not consenting to. So, to that extent, having a framework in place that requires users to be notified of certain items, having that easily accessible is something that we do see as a welcome change, especially because while juxtaposing with the fact that not all users are going to sort of go ahead and consume this document, you are sort of solving for the fact that that one user who will come and read your notice, who will come and enforce their rights under this law. And to that extent, it does sort of, encourage organizations to build in privacy by design and build in the systems to sort of ensure that you are complying and having adequate data, having adequate protections for the sort of rules, for the sort of compliances that we are seeing coming in under the DPDPA and the rules. The effect that also has, from the perspective of being able to do business, is we do see a lot of foreign laws that require data transfers to be with a region that has adequate measures of data privacy in place that is there under the jurisdiction that you're probably looking to deal with or looking to access data of. To that extent, it does help India sort of take the steps towards being that adequate jurisdiction and assist us in sort of telling these sort of the companies or the private parties that we deal with that, hey, there is a privacy law in place that sort of ensures all of this, and we do have adequate data security measures as under the law and translating into our systems because of that. So to that extent, having a data privacy law does help in certain cases. Having said that, seeing the content of the law that has come through, there are, of course, certain issues that we do see under the rules. And I would just like to take a moment to sort of touch upon the sort of key areas that we see as something that needs to be improved on, needs to be deliberated more upon. Something that has already been discussed by Uthara on this panel is, of course, the perspective of the fact that there needs to be adequate measures for you to sort of take consent of children. Adding to that complexity, the provision doesn't just stop there; it also extends to you requiring verifiable consent of lawful guardians of a person with disabilities. Now, if we were to talk about that provision in specific, the definition of persons with disabilities that we do see come across is not a very easy assessment that a tech company or a company can make. So to that extent, what we would like to see as a clarification from the government is a sort of really crisp sort of definition on how a company can sort of identify which user would be a person with disability, and therefore go ahead and bucket those users and comply with the law by requiring them to provide the consent as the law may require. Just to throw light on this, one of the current definition under the rules basically says that any condition that sort of restricts a person from participating in society. Now, when we talk about society, it is a person participating over the internet on an internet platform is very different from the capability of a person to participate in society. So to that extent, there is a lack of clarity under the rules of basically understanding user behavior and how these sort of users interact with internet platforms. And that is something that we would like, a clarification to be issued for us to sort of understand what exactly is the identification mechanism we need to have in place to sort of identify these users. The second issue that we do see with this is the wording. The wording basically says that before you process any information of these users, you need to ensure you have verifiable consent. I mean, in essence, it is something that cannot be solved for, because you will be processing certain information of these users, of their parents, for you to be able to make that determination. So, I mean, we are in sort of a place where you are in automatic breach of the law because you are asking the user to sort of provide these documentations to you. And in essence, you will be processing this data. Moving on, I think the next big thing is, of course, the data deletion provisions that we have now gotten some clarity over. Under the Act, it was very, very unclear of what the completion of specified purpose would be, and the rules have sort of helped us understand what that is. Having said that, the parameters that are sort of given under the law is on the basis of entities having a certain number of registered users. Now, given the fact that we are giving the user the ability to sort of go ahead and ask their accounts to be deleted, ask their accounts to be purged, how is it that an entity will make the determination of the number of registered users on that platform? That is a clarity that we do need under the laws to sort of understand whether you qualify that threshold or you do not qualify that threshold. Having said that, as an organization and as a tech company, it does sort of motivate you to have data minimization principles in place, to the extent that the lesser personal data that you are actually collecting and retaining, the lesser sort of compliance burdens and issues that you might have internally. So we do welcome the fact that there is some clarity under law of what they see as a reasonable period. However, we do have some way to go for us to sort of understand what those compliances will look like. I think touching on the last point for my opening remarks is, of course, Rule 22 that has got everyone's attention, which is the power of the government to sort of go ahead and ask data fiduciaries to provide certain information of their data processing activities or whatever data it may have. While we understand, the intent of it, what is really required in a delegated legislation is, of course, having principles in place to ensure that these powers are not unchecked and there is a proper system of checks and balances. What we would like to see under this rule is essentially to see the fact that the request that comes from the government must be a written decision, must have reasoned orders, so that as an entity receiving such a notice from the government, you are able to sort of understand where the government is coming from, and in case it does violate certain principles under law, you have the ability to have that written decision to go ahead and challenge that in an appropriate in an appropriate authority. So the other thing, the last thing that I will speak about is also the power of the government to basically ask the data fiduciary to not sort of go ahead and tell data principals that this is what we are giving to the government. We do see that as a bit of a juxtaposition of the principle under the DPDPA, which is to encourage transparency, which is to encourage users to have more control over their data. So, creating sort of like this framework where, this information is not going to the user sort of juxtaposes against the principle that is underlying this legislation. So I will stop there as my
Right. Thank you, Meghna. Thank you for providing all this information. So next we will go to Venkatesh, who represents an industry association, for his views. And after that, we would go to Anand and then Gowree. The lawyers will. So Venki, over to you.
Hi, Amrita. Thank you. Hope you can hear me clearly. Just checking. Perfect. Thanks, everybody. Thanks for the opportunity, Amrita. Thanks for tuning in to this discussion. So in my initial remarks, the primary intervention would be focused on three areas. As concerns, number one, the first focus area of concern is cross-border restrictions on cross-border data transfers. The second focus area is on data breach reporting obligation, and the third one being designation of significant data fiduciary. There are others. I might come to that if time permits in the second round. Just an introduction, BSA, the Business Software Alliance, is a global coalition of industry body for enterprise software companies. So our members are data processors in this ecosystem largely. I mean, they do have data fiduciary roles that they perform, but we represent the interest of the data processors in this case, or enterprise software industry, B2B software. So that is our vantage point in this discussion. So going back to the concerns in that order. So number one, Rule 12.4 and Rule 14, which bring about restrictions, which brings about data transfer restrictions, are both challenging and add to uncertainty in different ways, though. But they are quite challenging and add to the uncertainty of implementing these at scale. So let me start with 14. I think broadly they both are new ways to restrict data transfer, as some of the speakers pointed out before me. While the Act envisages data transfer restrictions through specified countries, for want of a better word, a blacklist approach, these provisions in the rules, they are over and in addition to that way to restrict data transfers as identified in the Act. So by that I mean, in addition to having a blacklist, the rules also look at data transfer restrictions that could be imposed, like through certain requirements, when the data is taken to a third country where the state has access to that data. Now, this puts companies at odds, because the jurisdictions of these two countries could be different, and it brings about a conflict of law situation. Whereas what we had suggested even in the Act and now is to look at it from the perspective of personal data transfer, to look at it to provide the same level of protection for that data across these countries. The government could evaluate contractual clauses or binding corporate rules to the extent that they want to enforce this particular Rule 14. It could be restricted only to the blacklist identified countries as envisaged in the Act. So that way, the Act and the rules are in line with each other. So that's for Rule 14. And for Rule 12.4, again, this is a blanket data localization that's being looked at, which is not something that the Act directly indicates. But yes, of course, it's possible that you could use those. It's all within the scope of the Act, no doubt. But it's again concerning to impose localization on a particular category of data, especially when the methodology by which the government might arrive at those data categories is slightly opaque, even at this stage of rulemaking. So that's number one. Number two is with regards to data breach reporting obligations in Rule 7. So there are two challenges here. One is that the businesses would have to report all data breaches. Now, personal data breach in itself, the definition in the Act is quite broad. It's very broad. And in addition to it, if all data breaches have to be reported both to the principal and the data protection board, that could prove very challenging. So we recommend here a risk threshold be looked at. While MeitY has opined that this is not something that they're currently considering, but this is our suggestion to look at a risk threshold, which would then help government and businesses focus on incidents that are of a high risk magnitude and then sort of prevent those breaches from further causing harm or increasing risk profile of other existing infrastructure. So that's one. And the second is timeline. Currently, all the information has to be reported within 72 hours. I mean, there's two-step reporting, and everything has to be reported within 72 hours. Challenging for businesses, especially as they're trying to fight the breach and also address the breach, and at the same time collecting all this information. The information, so a simple request here is 0 to 72 hours, 72 hours plus. So initial information within 0 to 72 hours, and the others after 72 hours. So I think that's the request with respect to data breach reporting obligations. And finally, the last point would be on the whole uncertainty surrounding significant data fiduciary. We thought the rules was a good opportunity to clarify the uncertainty that the Act came up with, where the 6 parameters defined for SDFs are left quite, if you look at it for businesses, the first 2 make sense. The remaining 4 are pertaining more to the national priorities. So the rules don't lend that clarity on who might be categorized as, which business might be categorized as a SDF, and add to it the 4 points on obligations, specifically on algorithmic verification, and then reporting the DPIs, the outcome of the DPIA, and that process has to be a synopsis has to be presented to the data protection board. That's also concerning. I mean, these audits, assessments, we support them, but then to proactively having to ask them to be submitted to the data protection board, that could be quite challenging. So with all those obligations, it's quite onerous on these. It adds to the uncertainty for an SDF. So those are my initial comments. Yeah, thank you.
Thanks, Venki. There was a comment by Jyoti, and I think I'll take it here. Is in Rule 14 forward-looking, the right to know, and therefore good for transparency? That is more knowledge of sharing of data with foreign intelligence agencies. Muted, Venki.
Yeah, no, Amrita, should I go ahead with?
And you can respond to it in the chat also. There are 2 questions, and we can, if not, we can take it during the Q&A. And with that, perhaps we'll move to Anand. Anand, you belong to a law firm. You've worked with corporates. How are you looking at this regulation, the rules actually?
Indeed. Good evening, everyone. Thank you for having me with this esteemed panel, Amrita. It's a pleasure interacting with this group. So as far as the initial observations are concerned, I will just make one overarching point, and I will give three specific examples. The one overarching point that I would make is the risk of over-engineering and making the entire compliance architecture overly burdensome. Now, what do I mean by this? Right? A lot of the discourse is changing significantly from what we were hearing in 2018 and what we're hearing in 2024. And now, what are some of the observations, right? One of the underlying bedrock, consent. It's not a silver bullet. It's not a cure-all for everything, right? So we want to process data. We want to do it with consent, and we want to do it with transparency. Now, that sounds very good in a discussion. It sounds very good from a philosophical standpoint. But what has happened in reality is the whole concept of this privacy architecture and consent fatigue has set in significantly. I'll give you a very specific example about that. When the UK Information Commissioner went about and tried to gauge how this was working, were the data subjects aware of their rights? Are they aware of how to exercise their rights? The reporting of that was as low as 30%. And now keep in mind European societies, right? More digital awareness, higher digital literacy, higher exposures. And even in those societies, the levels of awareness with all of the implementation of nearly 8 years of architecture and compliance in place, the end result is a very poor outcome. So how do we take that learning and apply it now to the new DP rules? Now, the point I'm making here is very direct. We have this strange dichotomy in India, and I say this partly as a practitioner and also as a professor at Jindal. We have this strange dichotomy where there's very high levels of compliance with a small sliver of very large companies. Typically, they're in tech, banking, or healthcare, right? But it's still a very sliver of those companies in those sectors of a very large size. The levels of compliance for the rest of the 90% companies is almost absent. Everyone has a fancy, privacy policy, terms and conditions, but very few companies have done the heavy lifting of privacy impact assessments, data classification exercises. So the architecture that is being contemplated by the rules and the level of preparedness and the willingness to even start on this journey, there's a huge gulf if you take the Indian industry as a whole. And then what did I mean by that? I'll give you three specific examples about the over-engineering and the overly burdensome nature of certain aspects. I'll pick up from where Venkatesh talked about these data breach notifications. No doubt, everybody agrees there should be breach notifications. They are two-tiered notifications. But to reiterate, there should be a materiality threshold or a harm threshold. You compare any of the significant jurisdictions. You take Japan, you take Singapore. There is a monetary number. It can be as low as 500, it can go into 1,000, but there should be a materiality threshold, number one. And also the definition, mere unlawful processing and widening that to a data breach notification, and that too straight away to the regulator, and thereafter have a secondary 72-hour clock running. Quite honestly, how many companies are equipped to undertake such an exercise is a very open question. Point number one. Point number two, the same well-intended legislation, rules, regulations also says do an annual data privacy impact assessment. I mean, this is fantastic billing for the lawyers and the accounting firms, right? But an annual impact assessment without a trigger is again another high compliance burden. How many companies have this? Companies who are struggling to do basic corporate governance and statutory filings to say annual privacy impact assessments. This should not be a tick in the box and a pseudo exercise. An actual privacy impact assessment is a significant exercise the company has to undertake. Again, no materiality threshold. Annually do it. Third, again, to pick off where Uthara, Ganesh also mentioned a valid point. It's great in principle. We all want a safe environment for children. Absolutely, right? The intent is laudable. Every company representative here will be completely aligned with that worldview. But again, how are we doing this from an enforcement standpoint? It again comes back to what is this verifiable consent? Aadhaar, DigiLocker, pairing that with the APIs to actually enforce that verification. It's actually an elaborate KYC requirement. You see how banks are struggling with it, insurers are struggling with this. And I mean, I'm talking even government regulators. You and I, anyone who's tried to go through the PPF office with a name change, who will know how difficult it is to show parent name, child's name, and actually claim your statutory benefits, because one full stop dot change in your Aadhaar name triggers a whole list of mismatched identities. So it's, you know, Aadhaar looks very good from the outside. DigiLocker looks very good from the outside. But when you pair it to actual authentication and a service, our EPF and PPF would be a fantastic example. Just the initials in the front or back changes the dynamic and claims are stopped. So now to put that tree, when you're in a data minimization regime, to then start collecting so much of additional data, you know, that puts a whole different set of obligations that, again, will not achieve the desired outcomes, which is the safety for the child's environment. You're only increasing data collection, you're only increasing compliance burden, and you're not getting the benefit for which you're targeting. I will end with another third point here. Regarding children's rights and disabled persons, anybody who has worked with the disabled community, even the optics of it, there was a lot of, I don't use the word heartburn, there was a lot of concern to phrase a disabled person and you're infantilizing them. That was the feedback given. So maybe this was just from a drafting perspective. As a lawyer, I can be dispassionate about it. But just even the clubbing of those two in one provision is a little concerning. Why? Because forget the verifiable consent piece, right? What are the follow-through obligations? Blanket provisions. You can't customize or personalize the services. You cannot do any targeted advertising. You're just diminishing the whole experience a child will have online. We've all been through COVID. We've all been through climate change. Schools were closed last week for 6 days, 7 days where I'm from, all because of climatic conditions. Now, when this child goes online, it may be for art, it may be for education, it may be for culture, it may be for history, for learning. And if you're saying, I cannot as a service provider customize an educational outcome, I cannot provide or customize a service offering based on their pre-checked needs, you're again, are you saving the child from detriment and harm, which is again a fantastic original intent of 9(2) of the Act. It's a fantastic safeguard and it's a very clearly drafted provision. Why are the rules putting these blanket prohibitions? It's pause for thought. And number two, when we go to these disabled rights, the provision is so broad. Not everyone has a guardian in India. Again, this is, you know, it sounds so beautiful theoretically, right? If a person is a protected class, I can see the fantastic intent. The intent is these are protected classes, therefore need additional safeguards. But it is divorced from the reality of what is India. How many people have guardians even if they're disabled? How many of those guardians are technologically savvy? And more importantly, a lot of the disabled community also says they are feeling disenfranchised. Is there a type of disability identified? Autism is a very specific example. You may be disabled. You may declare and identify as disabled, but you may definitely have mental capacity to contract, mental capacity to agree how your private data is being processed, and you're disenfranchising everything with a very excessively broad net. So essentially to summarize this, you know, let's take some of the learning. You know, everything you put one terms and consent, one cookie comes up, you put one consent form, you're layering it and layering with forms. And it's as a lawyer, I feel it's an excessively legal solution, which is divorced from the practical reality of user experience, user safety, and your actual desired outcome. So we'll go into these in a more granular detail and we'll address some of these rules at a point by point. But just keeping in mind that overarching debate on how in Europe, the jurisprudence was such in 2018, European legislation could drive discourse across the world. But now as we go into 2025, 4 of the top 5 economies, only one is a European nation. That is going to change even further as we go into 2030. We need to form creative solutions. So this is the irony, and I'll perhaps end with that ironic note. Everyone agrees about the safety of the child in the ecosystem. Everybody agrees that it should be transparent. But these are words. You can't say draft a notice that is transparent. What is a single privacy policy that we have read that is less than 3 pages long, which does not have blanket processing of that information, which everybody clicks yes to continue? So with that note about the singular caution about over-engineering and making this so administratively burdensome, and all of this pushback, ironically, is happening in Europe itself, where consent fatigue has set in, innovation is stalling dramatically. This pushback is happening real time in Europe itself, and India should be careful to learn from their mistakes and chart our own path. Over to you, Amrita.
Thank you so much, Anand, for raising quite a few points. I do see the chat moving. So speakers, please feel free to, join the chat. And with this, I move to my friend Gowree. Gowree, your thoughts on this?
Thanks, Amrita. And I echo whatever has been said thus far. When you are the last speaker, you either get to just summarize things, or maybe add things which are probably giving a different perspective. So before I delve into rules, what I feel based on whatever everybody has said. Number one, what is the simultaneous requirement, for the operationalization of the act? Is some kind of an FAQ which supports the act and the rules that will come in legislature, but the industry does need some guidance perspective. I can give some examples, right? Quite a few times, you have consents going from offline to online. We had a colleague talking about, say, healthcare industry, right? When the diagnostic person comes at your residence, they take a signature on certain form, which is physical, and then that consent is moving to a digital format, right? So some of these elements, sort of giving guidance to the industry in an FAQ form, I think is a must. And I don't think we have got a complete, sort of fold of the act yet, because there are several things yet to be notified. Because what we have today, just for the audience, is only the rules which, operationalize certain parts of the act. But there are certain notifications to be issued. For example, who will be categorized as SDF? Which countries, the data cannot be transferred, right? There are certain other notifications as well under the act. So to see the complete overall picture, as we say, the picture abhi baki hai, right? So that's yet to be seen. Now, something to do with the specific things, that some of the sort of panelists have said. I want to just quickly add to that. Now, children's data, Uthara, I could not have said things better than what you have said. I just want to sort of give an additional perspective as to what could be the way out, because we have a letter of law, which is in your section 9, but you do have 9(4). And with that, you do have the rules in Schedule 4, which have given certain exemptions. So current exemptions are only for healthcare and education, and sort of around that, right? So can we work with the government, with some additional exemptions that just takes away the entire conversation of parental consent, right? So I think some of these, because I believe MeitY also would have recognized, and that it's not as simple as it seems to operationalize parental consent. So I'm just trying to suggest a via media we can consider, apart from all the other things that have been said. I think the breach notification, again, I'm just reiterating that unfortunately, when we tried through the earlier industry consultation to have a threshold, for the breach notification, unfortunately, that was not accepted in the main act. Therefore, unfortunately, in the rules, also we can't, have that which sort of overrides the act, right? The other issues on that breach notification that have been pointed out is essentially, what rule 7(1)(c) and D require is that whatever remedial measures that you're talking about have to be immediately informed, right? Now, that is something not possible. The way we have considered two-step process for the board, right? A similar two-step process for the notification to the data sort of principles could be considered. Of course, it has a double whammy, because that means that many that means so many breach notices that you will keep getting. But again, from an industry perspective, that is some via media can be considered as such. I think the erasure is another element, currently and one other thing, for the participants, when you read these rules, you have to actually focus on the schedules more than the rules, right? So the schedules are telling a lot, in terms of operationalization. For example, erasure, they have identified some guidance only for e-commerce entities, social media intermediaries, and the gaming intermediaries, right? Can we have, more guidance, or rather for additional data fiduciaries, can we have, guidance? For example, fintech entities, for example, say healthcare industry, right? Is there any additional guidance from an industry wise? Because the rule is, sorry, the act itself is not giving you much guidance, right? The other important element that I want to point out is the notice for the past data. I think this is one important element which I understand. For example, say BFSI sector, healthcare sector, they must be sitting on huge amount of past data. Now, there is no clarity as to how the notices have to be given. For example, the questions are being raised that if I have one email address which is in my system, if I give notice only to that email address, is it sufficient? How do I know that email address is still operational, right? Some of these practical elements are coming up. Also, the timelines within which you need to sanitize that past data, right? Considering the humongous data sets that, yeah, and this will apply even to the government. I mean, we should also recognize the government is equally a data fiduciary. So, these timelines for the past data are going to be extremely important. I think on the last couple of quick points on the SDF part, right? I think one other question, I echo the fact that impact assessment need not be annual. It could be as the new processes come in, or new types of data are being processed, etc. Right? So there are certain trigger points that one can identify, but also in the drafting there is some confusion as to whether the impact assessment also has to be by the external, sort of auditor, or it can be internal, right? Because the act doesn't necessarily contemplate an external auditor. So, some of the feedback is around that as well. I think, the last point, which I want to just call out is the consent manager framework. We have no visibility as to whether it will be effective, not effective, because the whole purpose of consent manager was, to sort of ease the, giving of the consent, withdrawal of the consent, and the like. There are detailed rules, detailed schedule in terms of the eligibility criteria, etc., etc. However, the actual APIs, how they will work, how they will integrate, we don't have visibility. And account aggregator framework is something we have seen in the fintech sector, but overall for the other sort of fiduciaries, how it is going to pan out is something we do not have much visibility. So as Anand was saying, that that entire consent fatigue and all of that, I don't think we have a solution as such through the consent manager yet, till we have some kind of sort of more detailed discussion around the operationalization of this framework. So I'll stop here, and thank you, Amrita, for this opportunity. And as we go along, maybe more.
Thank you so much, Gowree. And while the next question to all the panelists would be what should be a recommendation, but you can think about it a bit, and you can always contradict each other. But I'd just like to ask the people in the audience that have any of you, apart from that, any concern which you would like to raise? Perhaps you can raise your hand, quickly take it. 2-3 of them. Has any other concerns? And incidentally, we do have people from MeitY who are as observers in the and I do see Kamya. She has a question. Are there adequate protections under the rules related data breaches? Do such breaches need any additional protection? As at this point in terms of concerns?
Is the question open to the floor, Amrita, or is it addressed to someone specific?
Yeah. Would anyone want to answer Kamya's question?
All right, I'll take a stab at it, especially the second part. I'm very wary of in your DP rules to have sectoral differentiation for data breach notification, because it's all blurring. What is a tech company? What is a fintech company? What is a medtech company? The line is blurring very fast, especially when it's AI enabled, So my first thought is there are protections. We've in fact discussed it. The protection and the reporting obligations are onerous. There's a strict timeline. You have to do it in 72 hours. Whether it is adequate or not actually depends on the enforcement. How the board is going to be set up, who are the people, how quickly they appoint the people, how quickly, so there's the whole enforcement architecture, which, we still have very limited visibility on that, on how it's going to function. That will be the true test of whether it is adequate or not. But to the second part of the question is sectoral, and depending on severity and difference of industry will truly set the cat among the pigeons. And I would personally be more comfortable with what is the materiality of the breach, what is the threshold of the breach, and for that to be the driving force as far as the notification requirements are concerned.
Thanks, Anand, for this. And Natasha from GSMA has a question on if there is any clarity on time period for compliance. For example, GDPR had 24 months. I think, Natasha, the rule, the documents say that, based upon the rules coming into effect, there would be a particular timeline. That's what I remember. Based upon the rules being adopted of the different aspects, and the experts can correct me out here. But I think I'll go to the part, we do have, the concerns have been raised, but what are these suggestions or recommendations we could kind of make? I think that is important going forward. So anyone who would want to take it first, should we follow the same way we went with perhaps Vishal speaking first, and then we go to Jhalak and the others? Do we do it that way, or anyone wants to go first?
Or we could reverse it to hear Gokhale speak.
Okay, yes, Gowree, you can go first.
No, I think while, I was raising concerns because of, I could see that we are sort of may get out of time. I've already given my sort of suggestions. So, for example, I think in Rule 3, right, we need clear understanding on the past data. So I'll now go rule-wise and, quickly give comments. For the past data, how the notice should be given. What is the timeline within which the data needs to be sanitized? I think we need that clarity. Then on the consent manager framework, there are certain provisions in the schedule which talk about that which basically indirectly say that the consent managers need to be data blind, right? That means they will not be able to have access to the data as such, but there are certain provisions which also say that they will maintain certain record, for example, consent given, etc. So we need clear understanding as to what consent managers will have, which data the consent managers ought to have access, what they should not have access. And then because they also say that the data subject or the data principal needs access in a machine readable form, right? So some of these elements, it's not fitting in clearly when it comes to the consent manager, because also if you see the consent managers, the security element, right, that some of us have been brought on. So if you really see rule 6 gives details about reasonable security practices for the data fiduciaries, but they do not do so for the the consent manager. What I'm told is maybe that will come through the board. Now, this is where the confusion is, right? Some things are coming from the ministry or the government. Some things may come from the board, right? So if that is going to come from the board, I hope, it's almost equivalent to the data fiduciary compliances, because obviously they also will be sitting on some of the data sets, right? So that is something specific on the consent manager. I think on the reasonable security safeguards, My comment is, I think more or less it seems fine what they've stated in clause 6. But I think somebody pointed out about whether my data is sufficiently protected from a breach notification perspective. I think the focus should be on how your data is secure in the first place, right? So in that context, I feel they do have some language to say that you will have detection mechanisms and things like that. But even the identification of the breach, because what we understand and this has been unfortunate part, that the companies or the entities do not even realize that the breach has happened, right? So more sort of guidance is required through the rules and in terms of what or maybe FAQs or whatever it may be, to give guidance as to what are the systems that need to be put in place to even identify those breaches. Right now, I think on intimation, I've already clarified what is required. I think I'll stop here because rest of it I've already covered. When it comes, sorry, one other element is on the on Rule 12.4, right? Insofar as significant data fiduciaries are concerned, I think it doesn't sit well within Section 16 of the Act. Which sort of when we talk about data transfers. So I think somebody already pointed out that this clarity is required, or rather, I would say that 12.4 is not required, right? Let things happen under Section 16 by notification or otherwise, and I don't think we need something separate, for SDFs. From a security additional measures, because they hold additional data sets, all that, for the audit impact assessment is already provided in the Act, right? So additional, such provisions, I don't think is warranted. It is not even sitting well within, the construct of Section 16. I think I had comments from the schedule which we have already provided, but happy to take questions, Amrita, as and when those questions pop up.
Right.
Over back
Thanks.
to you. Yeah.
Yeah, thanks a lot. There is a question from Naman. I also had a question a few days back. I was speaking to some in a company, and they were saying that, there is an exemption which is provided to publicly available data. The question was, how does one discern it is publicly made available? Sometimes data is everywhere, and, would later on the company get into some kind of a liability, was a question. Is that a concern which you all see? And
I think that if I may just quickly take that, no, that's a good question, as to what is publicly made available, right? So there are two possibilities where I myself put my data out there, right, on say social media platforms or otherwise. And secondly, the law requires the government. So suppose government is sitting on some data, and this is example which we constantly get is how, the MCA puts out the director information, openly on their website, right? The contact details and things like that. So there was certain concern that was being raised. Now the question is, the government itself will have to look at, one is from the company perspective, but I also want to raise that question from a government perspective as to what data, is required by law to be set out there in the public domain, that, clarity is clearly required, to be brought in. And now answering that specific question, unfortunately, what has happened, in last, over a period of time, there has been data enrichment, and the companies are sitting on huge amount of data sets. There is a possibility that certain data set, has been obtained by consent. Certain data set maybe, through the public data, right? Unless the companies are able to figure that out, because, the Section 5.2 says that, okay, if something you have obtained by consent, you don't need to go back, things like that. But there may be certain data set which are even exempt because they were publicly available. But if you have enriched your data source from multiple places, you will not even know what is the source of that data. And that is where, Amrita, I believe the danger lies, that if I'm not able to figure out the source of my data, and you believe that that data may have come from some public source, which in fact it hasn't now, and then you also don't, rationalize your consent for whatever reason, that is where I think, the things may fall through the cracks and the liability may arise. I know it was a long question, but I'm sorry, answer, but that's
yes,
the way I'm
I
looking
think
at it.
that was what their concern was. They may not really know about it. So Anand, over to you. And there are, just in case when you're speaking, there are two questions in the chat. In case you want to even refer to them, please feel free to do so.
I'll pick up on that AI ML question. in the interest of plain speak, I don't think, I mean, maybe I'll make that harsh statement, right? I don't think the existing privacy regimes are entirely suitable for AI ML, specifically the training of the large language model. And I'll tell you what I mean by that. Now, everything here is viewed as an individual data set, personal identifiable information tied to a singular data subject. That subject can give consent, that subject can withdraw consent, and you will accordingly delete that information, sanitize it, anonymize it, whatever buzzword you're using, right? It's a very simple construct. And that you can do in a social media, you can do it in a search engine, even though they struggle, you can still technically do it. Now, large language models is aggregating that data, and it becomes like an entirely trained model. And when you speak to the data scientists, minor tweaks of removing singular data sets leads to systematic failing of the large language model itself. Now, whether that is positioning by the LLM companies or not, I'll leave it up to you. But when I try to understand the science behind it, it is extremely complicated to take a trained language model and individually start pulling out data or even identifying where a data that was trained, maybe it was in the public domain, maybe it was in consent, and thereafter pulling it out is actually an open question. People are grappling with this issue, and I'd like to hear if my co-panelists have a different opinion on that. I think this is a very good question, and I don't think there's a solution for already trained. There's many complex ways where you can do it, but the cost and the retraining of that same LLM is so prohibitive, where if you have every few months, couple of 100 million people changing the consent mechanism for processing it, the viability of the LLM model itself, the viability is coming into play. And I'd like to hear what my panelists say about that. As far as recommendations, and I like that we pivoted immediately to recommendations. I will just make 3 recommendations, Amrita. Number 1 is regarding child rights, right? More specifically, the Rule 11 and what are the exemptions in in Schedule 4. And I'm tying it back to this AI and educational outcomes. Everything is changing at such a lightning pace. And whether we like it or not, a lot of the AI is in fact driven by 4 or 5 large corporations. It's the nature of the beast to afford the graphics, to afford the servers, to afford the $1 billion of investments. It's a very select few companies. And they don't identify as educational companies. They don't identify as healthcare companies, even though many of their software arms are branching out into those sectors. So I would ask us, as far as the first recommendation is concerned, to surgically tweak the exemptions for processing, not just for educational institutions or medical establishments, but see, for example, I do a lot of learning on YouTube. If you learn a musical instrument, if you are learning for, any complex how-to-do list, a lot of it is coming from what you would even perceive as social media companies, media streaming companies. So first recommendation, especially to keep our younger generation competitive, allowing them to have access to personalized, customized content from a language perspective, from a degree of sophistication, which year they are in. So when I log into a system, I'm able to understand by past usage, this is the grade they are in, this is the level of understanding they have in the subject, this is the type of language that they would prefer. All comes down to personalization of services, and Schedule 4 exemptions should be broadened. Recommendation 1. I just have 2 more recommendations. So while this is a more surgical tweak, I may take a little bit more maximalist position for Rule 10.1, this verifiable parental consent. And I will go back to how the Companies Act came forward, right? Many people hated the way it was rolled out, right? It came in batches. But there's many low-hanging fruit, right? We've been talking about this act itself for half a decade. The rules itself have taken enough time. So I would say certain rules can be kept in abeyance and perhaps not notified. Now, this verifiable parental consent, till there is an industry agreement of what is the solution. Is it paired to DigiLocker? Is it paired to Aadhaar? What does that API look like? Is that API scalable? Is it available to all companies? What is the cost associated with it? Can a smaller company do it? Can a larger company do it? Until those issues are addressed, perhaps 10.1, you can keep the notification of 10.1 itself in abeyance. It's a maximalist position, no doubt, but that would be the recommendation I make. And the last point I would make is regarding this deletion of data. This is particularly Rule 8.1. And again, it comes back to that over-engineering concept, right? Not everybody logs into accounts every day, and let's take e-commerce, for example, or OLX. I may sell a car. I may not go back for another 3 years, but I do like the convenience of my payment information remaining there. I would like to know the comparison of what I sold my car for last. So no doubt, 8.1 specifically talks about deletion for inactive accounts or when, quote unquote, that legitimate purpose has been satisfied. So when we're talking about our ecosystem, it comes down to the practicalities of it. And the reality of it is very hard to acquire a subscriber or a user. It doesn't matter if you're a Swiggy, Zomato, Blinkit, it doesn't matter. The highest cost for Indian startup industry is a customer acquisition cost. And the second highest barrier in that customer acquisition cost is for them to pony up their credit card information, right? Because the money is where the profit is, and people are very wary of it. And now we already have separate RBI regulations and guidelines. It's already tokenized. The security architecture is in place. There's two-factor authentications. So we have all of that data security mechanism in place. And just because the account is inactive, you say you stop using all of that. What if it's bricks? There's 99 bricks. I'm not coming and selling a house or an apartment every 2 weeks. I come back once in 3 years when I'm in the rental market. I come back once in 4 years if I have a property to rent out. So I would be, again, very surgical about 8.1, this data deletion requirement, and be very surgical about what do you mean with an inactive account, and especially things like payment details, address, verification. This should definitely be allowed to be retained, even if the account is inactive, and deal this as a security issue. If the account is inactive, there's no privacy risk in my mind. It's a security risk. Will the passwords be intact? Will the servers maintain the credit card information securely? So as far as that inactive data deletion requirement, I would not frame it so much in a privacy lens, but I would frame it in a security lens. And all of this, we have a lot of ancillary legislation already taking care of that. So to summarize my point in one sentence, let us be surgical in our approach for customization of children's services to get good educational outcomes, good online outcomes. You don't want, TikTok is banned, right? We've seen how TikTok, they have a different name in China. You see the type of personalized content they put to Chinese children vis-a-vis what TikTok puts to the Western audience. There's a qualitative difference because they personalized it for their domestic audience to get better outcomes for their children. So strategic approach, widen that definition in that exemptions, not just for education and medical establishments. Number two, take a maximalist position. This verifiable parental consent. I've tried to work with backend technology teams. It is not an easy solution. And lastly, as far as this data deletion for inactive accounts, it's a security issue more than a privacy issue. And definitely for inactive accounts, it should be retained. Those are my submissions, Amrita.
Thank you so much, Anand. And Venki, over to you.
Yeah, thanks, Amrita. Just waiting for hopefully you can hear me now.
Yes, we can.
Perfect. Yeah. So, I did give some of my suggestions already in my first intervention, but I'll try to keep them brief. Because I'm struggling with the character limit on substantiating my recommendations. So on Rule 12, I have 4 recommendations. Provide clear criteria and process for SDF classification. Remove mandate on data localization. That's 12.4, which Gowree had pointed to. Delete requirement 12.2 to provide significant observations to the data protection from DPIAs to the board. And also delete requirement 12.3, given it's quite vague as to what verify algorithmic software is. To the extent possible, if it's relating to AI, then these can be dealt with in AI-related policies. Then with regards to processing of personal data outside India, international data transfers, delete Rule 14. If Rule 14 is retained, it should expressly permit data transfers and ensure that these restrictions or certain requirements, quote unquote, should only come into measure where certain countries have been identified as blacklisted countries through due process. That's with respect to Rule 14 and 12.4. Rule 7, intimation of data breach, introduce a risk threshold, allow greater flexibility in reporting timelines. Rule 3, the next one is Rule 3, where the notice, as far as the notice is concerned, looking at, and I'm trying to tie some of the questions that came in the chat. So we do think that, we do see that the rules are rules sort of build on the consent-heavy framework that the Act puts out. This could be a challenge for, implementation of data collection in the AI landscape or context, but we'll see how 7A is used. So the recommendation here is more flexibility in notice requirements, and the government to consider additional lawful basis for processing under legitimate interest. So that request continues. Rule 22, I want to say, quite vague, uncertain. So even here we recommend deleting 22 or making it more specific. There's also the use of the term intermediaries in Rule 22, which makes it applicable for fiduciaries, processors. We'd like to point out processors don't own the data, or we control the data. We are acting on behalf of the fiduciary, so it would not be possible to share information or data. So that's on that. Finally, on reasonable safeguards, tweaking the language to ensure that it's not prescriptive. So at the minimum can be changed to as appropriate, and the 1 year timeline for prescription of logs can be removed, so that businesses who don't require 1 year can take their call for business reads. So those are sort of the main recommendations that I have.
Thank you so much, Venki. And I think next would be Meghna, right? If I'm not mistaken.
Yeah, so to provide concluding remarks and just final sort of recommendations on the rules that we have. So in addition to the points that I touched upon in my opening remarks, the things that we would want the government to sort of provide more clarity on is, firstly, and something that we've already spoken about in this forum, is the scope of exception for publicly available data. So, just building on the discourse that has already happened, just by the fact that if I were to volunteer certain information of my personal data on an internet forum and an available forum, where I would say, for example, that, I'm having this fundraiser, these are my account details, this is my number, that does not sort of, lead to an exception being created where I'm now expecting and having companies reach out to me basis this personal data that I've shared, right? The point being that even where there is publicly available data, and something that jurisprudence on privacy also recognizes, right? Even if you are a public personality, you do have a certain expectation of privacy. And that privacy expectation is also very contextual. If we come back to the Act, we do see that the fact that there is some data that I am volunteering, I need to be made aware of what that data is going to be processed for. So where I am giving certain data in public forum for a certain specific purpose, it does not lead to a situation where, that purpose is sort of extended just by virtue of the fact that it's publicly available. So contextualizing this further, and fleshing this out further is something that we do think needs to be properly fleshed out under the law. Secondly, on notice requirements, and when I say this point, I don't believe that maybe having it further fleshed out under law would be the correct forum for it. But having industry discussions, having stakeholder consultations, and also seeing how the industry evolves in the formats and the level of detailing that companies go into to sort of inform users of which data they are taking and what sort of processing activities are going to happen pursuant to that data, is something that we as an industry will need to build upon once the rules are operational. And to be fair, this is a point that even matured, data jurisdictions like the EU have not been able to sort of solve upon yet, where even in the EU, we do see, like a liberal interpretation of the requirement to provide detailing of processing versus a strict interpretation where you need to, tell the processing and identify specifically which data exactly you're going to be using for that processing. So that is something that we hope to see evolve pursuant to further jurisprudence that will happen on this issue. Thirdly, on the point of requirement of notification of breach, I think the term breach needs to be further fleshed out under law. Is it that me discovering that there is a bad actor in my system who maybe has not stolen any data, maybe has not, done any sort of adverse actions? Is that something that qualifies as breach, right? So having those parameters in place to sort of identify what a breach looks like for me to be able to operationalize a framework where, pursuant to this breach, these sets of users need to be notified or not, is something that we believe needs to be more fleshed out under the law. Now, coming to the questions, and I do want to address a few questions that have come into the chat box. I think one of the questions was about how companies can ensure they're DPDP compliant in case there is an employee sort of doing data theft. So the DPDP sort of does give you a sort, like base frameworks or base security protections that you need to put in. For example, you need to sort of have limited access to that data. You need to maintain logs of who's accessing that data, have like verifiable audit trails of where that data is going, etc. So firstly, implementing those measures as an organization to ensure that data is secure, data is protected, and not everybody in the organization who does not need to have access to that data does not have access to that data. And secondly, touching upon the how would you deal with a situation where a data theft has happened by an employee. It is very to have adequate contractual provisions in place so that you action against this employee, and in case there is some certain breaches, etc., that have happened. This also brings me to another question, I think, which somebody asked about processors and the the requirement of processors to sort of get consent from data that may receive from a data principal. So the way DPDPA works, the onus of taking that consent is on the data fiduciary, on the data controller, and not on the data processor. However, having said that, what the DPDPA does entail is that in case there is a data breach that is happening at a processor level, it is the data fiduciary that will be liable. So tying it back to my first point, it is very important as an organization to sort of have contractual provisions in place with your employees, with your data processors, to ensure that the data processor or the employee is sort of adhering to the similar obligations that you have as a data fiduciary, and for you as a data fiduciary to also have enough mechanisms where in case of a breach you have contractual protections in place for you to take adequate action against the data processor. Maybe that could be through auditing the data processor systems, or having an indemnity in place, which is something that a company can take on a case-to-case basis.
Thanks a lot, Meghna. And with that, I move to Uthara.
So the joy of working in Indian tech policy is that you can count on a ton of really solid people to make all sorts of valid points in a very compelling way. So I have a couple of plus ones and one last remark, which will be pretty unsurprising to the audience, considering it's on children's data. Big plus one to Anand on his point about overall enforcement capacity in India, especially for smaller businesses. Another big plus one to Gowree on the point she made about the mismatch between the parent law and the rules, right? Specifically on data localization and then the algorithmic disclosure provisions. I know that Meghna made a really great point about a clearer definition for data breaches, as well as defining what a material threshold could look like there. So agree with all of that. But candidly, if there's a single issue that I'd like to underline, folks, it is the fact that we need to think about children's data outside the purview of parental consent in a separate policy instrument. I think this provision, honestly, has got so much airtime in the last 4-5 years. And it's because it emerged as the most architecturally complex, right? That, I think, combined with the fact that 40% of India is under the age of 18 almost, means that we are going to have all sorts of unintended consequences from this particular provision, right? I think Anand already made this data maximalist point very compelling, I have to say. I think, look, while we look at pragmatically accommodating compliance here and trying to make this work, and I want to commend MeitY on that, I think it's a useful thing to do. I do think that as we move towards enforcement, we're probably going to unearth like a million really difficult implementation problems here on verifiable parental consent, right? And I think, frankly, the earliest long-time solve here is to just do this differently in a separate, considered discussion on potentially creating like an age-appropriate design code sort of thing in India. So yeah, that's my overall comment. Thank you so much, Amrita, again for the opportunity. I'll stop there.
Thank you so much, Uthara, for this. And Jhalak, over to you.
Thanks, Amrita. I think one of the points I want to sort of start with is one of the last provisions in the law, which is the government access to data question. I think that the minister in some public comments has also indicated that they could ask encrypted apps for data as well through this. And this language doesn't really comply with the standard that's been set by the Supreme Court around proportionality and lawfulness of things like accessing data. We have the Information Technology Act, we have the Telecom Act, all of which have some level of procedural safeguards which narrow the way government can ask for access to data from corporations. There is a committee, albeit it does function poorly, but it's still very much there. So this rule kind of completely sidestep whatever procedural safeguards we see in some of the other laws. And this is, in the larger context of the fact that India's entire surveillance framework is currently under challenge, through through the court system. So I think this is, one big point sort of to keep in mind as we frame recommendations and as we frame feedback. The other thing that I feel has sort of just found mention in the rules is on impact assessments and audits around algorithmic transparency for platforms. And this sort of goes beyond what is envisaged under the Act. And there really isn't much guidance on what is expected, what is the mechanism, who's going to check that, companies are actually doing this. And, as one of the panelists mentioned earlier, we don't want it to be a checkbox exercise. And, if there isn't clear guidance, there isn't clear oversight, then it's going to become, there's no incentive for industry to effectively actually operationalize and implement. So I think, this may not be the right forum to necessarily be bringing this in. I think the other thing, I saw some questions in the chat on exemptions. One thing that is missing from the law, and not that it could have necessarily come in through the rules, but is the need for journalist exemption for handling data. On the erasure sort of point within the rules, I think it would have been useful for the rules to engage with various forms of erasure, including de-indexing of data from search engines, etc. And it's not been clarified by the government in the rules. And it would have been useful for industry to have this clarity around whether de-indexing is being treated as part of the larger ambit of erasure of data. And I think the other point on erasure is the fact that while the Act does talk about the ability of users to erase data that has been consented to, but what about data that's collected about them which they haven't consented to? So that has, it seems very basic, but that's also something to sort of think about. I think I'll end with a broader point, which is that so far, the government seems to have only done closed-door consultation with members of the industry, which has been pretty disheartening. I think while, of course, industry is going to implement these rules and operationalize them, I think there's a lot of value to having experts from other cross-sections of stakeholder groups participate in these discussions, share perspectives from what's happening around the globe and through the work that they've been doing. I think, it would be really useful to see that the government conducts, town halls like they have in the past and other forms of discussions with various stakeholder groups, so that this is really a holistic and well thought through process.
Thanks, Jhalak, on that. Incidentally, the ministry did have a consultation last week, if I'm not mistaken, on this. They have, and as per reports, they did have one in Mumbai, and what the secretary and even the minister mentioned in the meeting, last week was they are open to meeting people and getting to know more, because I think they also realize complexity involved, especially the children's data, etc. They have themselves said it is a complex thing, and that is why they have been pretty open at this point of time to at least hear out. And I was there in the last week's meeting, and many from here were there. They were pretty open to hearing people, and they were pretty. One thing which they mentioned is we may not be able to do everything, but we could come to some kind of a common ground, is what they were saying. But I see Gauree's hand up, so Gauree, over to you.
Yeah, I mean, since you mentioned the Mumbai consultation, I was part of that consultation. And, I just really want to commend that all the three, the secretary, additional secretary, and the scientists, I think all of them were extremely well versed with the provisions of the law and the rules, right? So they were able to answer the questions, clarify the questions very well. So luckily you have a set of people out there who are, who have read the law, word by word. And they also recognize, as you rightly said, some of the difficulties, that we are facing, especially, on the children's data. I'm sure you also would have heard that, the question really is, how do you do data minimization but at the same time achieve this process? I think everybody is struggling on that, but I think everybody recognizes that, you cannot, for the parental consent process, sort of have that additional, data sets getting collected which are actually not required, right? So some of that balancing act, this is only an example, but I completely echo that, they are here to listen to us. I think only the timelines is a problem. If we get that additional time, there may be more industry consultations, hopefully.
Right. Thank you, Gauree. And with that, I'll come back to you for your last comments, but I'll open the floor. If anyone wants to speak, please raise your hand. Or, I could always have my moderator's privilege to call out people to share. I do see people from SFLC. I do see Rahul, and Jyoti is obviously there. Anyone wants to share something on this, or even raise a point? Please feel free to do so.
Amrita, Jyoti here.
Yes.
Great discussion, and thank you for organizing and bringing everybody together. Appreciate it. On the point of data localization, I think it's a very important point that, we keep seeing data localization mandates kind of sneaking into the sub legislation. Whereas there are certain categories of data that might deserve slightly different or more intensive protections until those categories of data have been defined and the harms arising or why extra rules or regulations should apply have been clarified. I think 12.4 is kind of problematic, and it creates a lot of uncertainty. So definitely would request MeitY and others to rethink bringing in such an important intervention through a sub legislation. On 14, I am still sitting on the fence. I would like to think that there is good intention behind it, but I also believe that Venki made a valid point that it would lead to it has dramatic implications for cross-border transfers and jurisdictional compliance. So maybe bringing in more specificity, specifying like the criteria or conditions for when 14 should be implemented, that would be beneficial too. Thank you.
Thank you so much. And I think Gangesh, would you like to share some of the points you have?
Yeah. Hi, Amrita. Thanks for this opportunity. And, like Uthara, I want to echo that every time there's a discussion, and there have been many discussions, each time there's always a new perspective that's brought out and a new way of articulating some of these concerns. And I think that's been exceptionally useful. So thank you for that. But just 2 points that sort of stem from the previous consultations and some of the discussions that happened in Bombay. One of the things that we raised during the discussion was the need to coordinate this breach reporting and security measures that come in under the privacy legislation, because there are, specifically with finance or with health, there are a lot of sector regulations that have features of reporting breaches and things like that. So there might be value in having a more coordinated response with the sector regulators, having that discussion and creating a more streamlined response to breach reporting, because that reduces the redundancy and creates a better efficiency and makes reporting more meaningful to both the government and to data principals as well. The other thing that I think, I'm sure this has been raised at some point during the bill itself, but the rules not so much as much. The impact on potential trade regulations, because if we are looking at specific restrictions like a class of data and to specific class of fiduciaries, we might run afoul of some of the international trade agreements that we're looking at. Even though we have exceptions for national security, there are certain thresholds and tests that we'll need to meet to have such provisions. So it may be that some of these measures might run afoul, and that might be something that you want to also look at. Some of the stakeholders who are facing this might not want to look at it as well. The third one is a bit of a wish list sort of thing, because I feel that we might have, really crossed that opportunity here. Is there, and as stakeholders, we need to work on this together, is to see if there is room for amending parts of the act, understanding that we're really stuck with rules that can't go beyond the Parent Act, right? Whether it is coming to verifiable parental consent, whether it's coming to the issue of, say, non-consent based data processing. Like I saw there was a discussion on legitimate interest, and even in other jurisdictions, there's a lot of interpretation and jurisprudence being developed. So which is probably intentional decision of the government to stay away from the concept of legitimate interest. But contract enforcement is a far easier ground that I think we should consider, and one that may require, it's a lot more of a low-hanging fruit to consider as well. So just these couple of points that I wanted to air for others to consider.
Anand, you can come in.
Sure. I'll just address a couple of questions raised here. And one was, what do you do in the event of employee wrongdoing, right? Maybe the company has done everything ethically, but the example raised was, what if an employee intentionally misuses, leaks, industrial espionage, however you choose to classify it? So this is an interesting question, and I'd like to hear how other panelists address this from a risk standpoint. The act specifically is not so much to prevent a data breach from occurring itself. And this is how you'll be drafting your contracts as well. It is the implementation of security measures designed to prevent that breach. So as long as a company can show that you took those security measures, the data were anonymized, you'll be surprised to know Fortune 500 companies, salary data, performance appraisals, they are stored locally in the hard drives. All right, there's no safe words, there's no password protection. If you're in HR, you have access to that data set. If you're an insurance provider, because you're processing claims, unencrypted, not on enterprise ERP software. We're talking about large institutions, financial institutions are saving very sensitive data openly in open shared drives. accessible only to certain members, but within large communities of, say, the HR function or finance function, you'll run into problem. But if you can club it with the Rule 6, show your security measures, show that your breach notification was in time, show that you have taken your remediation response, you can minimize significant liability to the company, even in the presence of intentional or willful wrongdoing on the company's part. Point number one. Another question, if you have a follow-up question, please raise it in the chat box. I will try to text answer any further questions. But because this is a very important point, because a lot of startups come and say, hey, there's no security measure that is foolproof. Breaches do happen. Ransomware attacks do happen. Here, more than brushing it under the carpet, more than even paying the ransomware attacker to release this data, it is your pre-effort in putting in the security architecture in place, training your team, securing that data on your servers, and dealing with it post-event, your interactions with the regulators. That will be your true shield against liability. Another question that was asked was also about the materiality threshold, right? Gowree has already answered it partially. It's in both ways, you know. So this way also the government was quite responsive. In a higher threshold, they identified who are significant data fiduciaries and those additional obligations, right? The impact assessments, internal audits, appointing these data privacy officers. They put these additional compliances only after a certain threshold has been identified and define them separately. And then, of course, as per Gowree's answer, even the startups, the notification has not come yet, but the anticipation is that it will be notified. So the startups also, you're minimizing their compliance burden. I just thought I'd take a stab at answering some of the questions there. Over to you, Amrita.
No, thank you so much, Anand, for this. Does anyone have any comments, questions to make? Because we have another 10 minutes, 9 minutes to be precise, or even the panelists, some comments. I do see quite a few people in the chat. Kamya, yes.
I just want to take, 2 minutes. I would treat this law, including the rules, the act and the rules, as a work in progress, right? Like we saw, I mean, insolvency law was a disaster, but like we saw, like Companies Act, insolvency, etc. Government realized that certain changes were required, right? So I wouldn't necessarily treat that it's a done deal even for the Parent Act. Right, we could still be at it. Some of us can be still at it to see, work around with the government. For example, the example that was given on Section 36, right? It's so open-ended even in the Parent Act, right? Requesting for the information, right? So some of these elements, I believe we could still continue to work parallelly. And I'm sure, if the government sees, sort of a good rationale, there may be some scope for amendments. I think, one of the participants did mention that, and it did come up in the consultation as well, right? So that is point number one. Point number two, let's push for the FAQs, in terms of to support from an implementation perspective. And number three is when it comes to the rules, whatever has been discussed, sometimes what happens is we just end up giving suggestions, but the drafting, the devil lies in the detail, right? So whatever suggestions we have, let us also work on the language. For example, we spoke about the additional exemptions for children, right? Let us work on the language. Let us give that language specifically to be included in the annexures, right? Or the schedules. So these are my quick, three broad points as the way forward.
Thanks so much, Gowree. And, just so that what we were thinking is many of the participants had been thinking, and I do see Deepika's hand. I'll go to her. In case you have any comments or questions or suggestions which you perhaps have missed, you could send it to us by tomorrow, and Swati would be sharing it in the chat, the email ID, so that, we could incorporate it as suggestions which came from the community. And yes, Deepika, over to you.
Hey, thanks, Amrita. And thanks so much for organizing this. It was a really informative session. But the main concern I've had with the draft rules is, I mean, there are a bunch of concerns, but I'd say the major one would be that of the consent manager and how that framework is really envisioned. So if you go back to the act again, it's again like a completely optional perspective from a data principal if they want to use one or not. And just to like, add to the complications, they gave the rules have given clarity on the fact that the fiduciary should not have a conflict of interest with the consent manager. So, I mean, again, just spitballing here, again, love to know other folks' thoughts here. But in the event that and again, like the data principal gets to choose the consent manager. So if they happen to choose the consent manager who has a conflict of interest with the data fiduciary, how does that really play out? And the other perspective is that again, this is not completely related to the rules, but I was just generally curious to know what would really be the revenue generation model for consent managers. So that would be another perspective. And again, I completely concur with the other panelists here. There could be a lot of work to be done with the verifiable consent provision as well. And even in terms of the illustrations that they provide in the rules, it's mainly, there are conflicting perspectives there, because a lot of people say that there should be like an actual knowledge threshold if you get to know the principle is a minor, like, do we have to go take verifiable consent there, or is there some sort of proactive measures that need to be inculcated? I mean, there's some debates over there. So I think with that, I'll just like I'll conclude here. So these are largely my thoughts on the rules. Yeah, thanks.
Thank you so much, Deepika, for sharing that. And I do see Venki's hand up, and I did see Gauree's hand, but I'll go to Venki first and then Gauree.
Yeah, thank you, Amrita. Firstly, I think I would like to thank you for organizing this online discussion. Quite helpful, not just to kind of go through my own points, because I'm constantly understanding, the act and the rules better by interventions from others. So thanks a lot. And secondly, as many participants echoed, having followed this discussion for nearly close to 9 years and even more, I think the robust, meaningful process that MeitY has undertaken for putting the act together first, and also the rules, definitely commendable, and making sure that they are listening to the feedback and considering all the comments that we make through multiple discussions is very heartening to see. So congrats on both those accounts. So thanks a lot. Yeah.
Thanks so much, Venki. Gauree, over to you.
I think I'll just comment on what Deepa said before, on this exact point on the revenue model, right? So what I understand that I don't believe the revenue will come from the data principals, though the consent manager are supposed to be my representative, right? That is not what is likely to happen. It is actually going to come from the data fiduciary, right? And how that is going to operate, we do not know. But that itself, whether it could be viewed as a conflict, right? So they need to clarify that if at all, that is a revenue model, they need to clarify that may not be treated as a conflict, right? The other question arises is when you have a conglomerate, multiple companies in a group company kind of a setup, and they want to set up a separate, entity as a consent managers just to operate, all of their consents, that may not get registered as a consent manager. Why? Because there is that conflict of interest concept that has been brought in, right? So but that could have been operationally so great in terms of managing for the group. So do they then not become a consent manager but have such an entity as an agent to manage my consents for the group, right? Whether some of these models will evolve, we'll yet to wait and watch. But yes, there are a lot of these gray areas when it comes to consent managers.
Thank you so much, Gauree, for this. And I see that more minutes. So I would like to thank all of you for participating, especially the panelists, and all the participants who have been patiently there for 2 hours in this discussion. What we would be doing next, as I mentioned, is once the record, we would be circulating the recording, and the team from CCOI would be making a report on this. Hopefully by at least next week mid, we should be able to circulate the report to all of you and also to MeitY. And then obviously based upon if we have time, we would be doing another meeting. We would prefer to do it physical, but in case we have people joining from across India, we may also go for a virtual meeting. So that's what we are looking for at this point of time. In case there are any comments, someone forgot to share today, please feel free to send it to us at info@ccui.in. By tomorrow end of the day, we would be adding it as comments which stakeholders have shared. With that, I would thank all of you for being here and sharing your views. Thanks a lot, everyone.
Thanks, Amrita, for this opportunity. Thank you.
Thank you.
Thank you.